Good afternoon, everyone. It's my pleasure to welcome you to our webinar, HIV and the Law, What You Need to Know. This webinar is taking place on January 16th, 2025, and you'll notice we are recording the webinar today so that we can share it with people who are not able to attend. This webinar is organized by the Manitoba HIV-STBBI Collective Impact Network. This is a network of innovators working collaboratively to transform the landscape of HIV and STBBIs in Manitoba. We bring people together to tackle complex HIV and STBBI systems barriers, and we seek systems change by shifting the conditions that are holding the problems in place. My name is Ella, and I'm speaking to you today from Treaty 1, Winnipeg, Manitoba. We acknowledge that we work and gather on the original lands of the Anishinaabe, Ojibwe, Cree, Oji-Cree, Dakota, Lakota, Inuit, and Dene peoples, and on the homeland of the Métis Nation. We are humbly working towards the Truth and Reconciliation Commission's calls for action and the Missing and Murdered Indigenous Women and Girls Inquiry's calls for justice through our research, events, and projects of the Manitoba HIV-STBBI Collective Impact Network. If you would like to find out more about the Collective Impact Network, sign up to receive our newsletter, find our social media or our YouTube page, you can do so at cinetwork.ca. This webinar is part of our ongoing efforts to provide education, and you can find past resources on our YouTube page, which is linked to our website. Today, we're going to have many opportunities for you to ask questions. The Q&A feature is enabled, and we'll be taking breaks throughout the webinar to address your questions. So feel free to put those questions in at any time into the Q&A feature. So with our housekeeping out of the way, I'd like to welcome you all, and I'd like to welcome our speaker today. André Capretti is a lawyer who works as a policy analyst for the HIV Legal Network, which is a Canadian organization that does research, litigation, advocacy, and education, all to promote the human rights of people living with HIV or AIDS. André works on a variety of HIV-related human rights issues, including in relation to Indigenous people, HIV criminalization, and the rights of 2S LGBTQ+ communities. Very, very excited to welcome André today, and I will let you take it away.
Thank you very much, Ella. I'm going to start by sharing my screen, my presentation. It is really great to be with you all today, virtually, online. I want to thank you for joining us today. I want to thank Nine Circles Community Health Center for inviting me and helping me to organize this talk for the Manitoba HIV-STBBI Collective Impact Network. And I want to start off by recognizing that I am joining you all from very cold and snowy Tiohtià:ke, also known as Montreal, which is the traditional unceded land and territory of the Kanien'kehá:ka people. And it's a place which has long served as a site of meeting and exchange amongst many First Nations, including the Kanien'kehá:ka of the Haudenosaunee Confederacy, the Huron-Wendat, the Abenaki, and the Anishinaabeg. So as Ella already mentioned, my name is André Capretti, policy analyst, lawyer. I work for the HIV Legal Network. We do a whole bunch of legal and policy work around HIV, around communities that are most impacted by HIV. And some of that includes public education work, which is exactly what I'm here to do today. So here is a little bit of an overview, a bit of an agenda for what we're going to cover in this webinar. We're going to talk about disclosure obligations and HIV criminalization, which may be a topic that you have heard about or an issue you have previously encountered either personally or professionally, or maybe you know someone who has faced this issue. So we're really going to unpack the topic, hopefully address some potential misconceptions, and inject a lot of additional nuance and perspective into any understanding that you might already have about these topics. I want to also recognize and acknowledge that some of this might be difficult material to hear about, to engage with. There will be discussions of HIV stigma, of criminalization, of sexual assault. And I also want to make clear and acknowledge that this is complicated subject matter. It's not easy, it's not straightforward. I'm going to try my best to simplify it, to make it easily digestible. That being said, please do not hesitate to ask any questions during the presentation. and I will do my best to address, to clarify, and as Ella mentioned, I'll be taking some pauses at different moments to see if there are any questions in the chat. I do also need to provide this disclaimer of sorts about what this presentation is and what it is not. So what I'm giving you today is legal information, not legal advice. And the difference between the two is, simply put, legal information has to do with providing you general, a general view of what the law is, help you understand the law. But legal advice is really about understanding how the law impacts you personally or individually. It's specifically about your situation and it can help you decide what to do. So if you need legal advice, I recommend you seek out a lawyer or a legal clinic to provide that for you. Today, I'm going to be giving legal information in a general fashion. And I also want to acknowledge that the law is ever changing in Canada. And what I am going to brief you all on today is current up to January 2025. So with that being said, I'm going to start from the beginning, and I'm really not going to assume, any level of prior knowledge. Obviously, many of you come to this webinar with a lot of expertise and knowledge on HIV generally, but we're still going to start with the basics. HIV, human immunodeficiency virus, is a virus which attacks the body's immune system, and which, if is left untreated, can progress into AIDS and lead to serious disease and death. We know that there is no cure and that HIV is transmitted primarily, but not exclusively, through sex, including through bodily fluids like semen, blood, rectal, and vaginal fluids. Now, the latest statistics tell us that there are more than 65,000 people in Canada who are living with HIV. And we know that of that number, roughly 89% of people are diagnosed, know that they are living with HIV. Of that 89%, 85% are on treatment, are taking antiretroviral therapy. And of those people on treatment, 95% have what's called a suppressed viral load. We do also know that, unfortunately, rates of new cases of HIV have been going up. We saw this with the latest statistics coming out in December from the Public Health Agency of Canada. And of great concern for all of us on the call, I imagine, is that in Manitoba, there has been a really pronounced increase in the rate of new cases, which is very concerning. So what we have today in terms of HIV treatment, ARVs, antiretroviral therapy, is highly effective. And how it works is by suppressing HIV's ability to make copies of itself in a person's body. So the number of copies of HIV in a person's blood is what we call their viral load. And when people take their medications as prescribed, they see a doctor regularly, they stay healthy, they can lower their viral load to a level which we would call a suppressed viral load. So I'm going to give you all some benchmarks, some numbers to keep in mind. And the first one that I want people to keep in mind is around suppressed viral load. So generally speaking, we define a suppressed viral load, and when I say we, I mean this is what the Public Health Agency of Canada uses, what the CDC in the US uses, as being fewer than 200 copies per milliliter of blood. And for many people, this will occur after taking HIV treatment for roughly 3 to 6 months. And a suppressed viral load is very important. It's an important benchmark for people living with HIV because it prevents sexual transmission of HIV, even in circumstances involving sex without a condom. And we know this with a high degree of certainty because there have been a great number of large international research studies which have demonstrated that people taking their ARVs, their treatment, who maintain a suppressed viral load under 200 copies per milliliter do not transmit HIV to their sexual partners. Now, the second benchmark I want people to keep in mind is one that, is increasingly familiar to the general public, but also people working in the sector, is an undetectable viral load. And that's thanks to the slogan of U equals U, which stands for undetectable equals untransmittable. And in terms of the numerical, the definition for undetectable, it can vary a bit because essentially, as the name suggests, an undetectable viral load means that that the virus in a person's body cannot be detected by most standard tests. But that does not, of course, mean that an individual has been cured. And that is usually anywhere between 20 to 50 copies per milliliter of blood. And like a suppressed viral load, undetectable viral load means that a person cannot transmit the virus to a sexual partner even where no condom is used. So that's very important as well. The third benchmark I want to highlight is one that comes to us not from the scientific community, but rather from the legal community from the Supreme Court of Canada. And it's what is referred to as a low viral load. And this is a very important legal benchmark that we're going to get into later on in the presentation. And it was set by the Supreme Court of Canada in a 2012 decision in a judgment in a case called R v. Mabior. So I want you all to keep those numbers in mind. 200 suppressed, 50 undetectable, 1500 for low. And now the fourth and final benchmark that I want to throw in there to add, even more nuance has to do with suppressed viral load. In the summer of 2023, around the International AIDS Conference, the World Health Organization released a new guidance on viral suppression. So obviously the leading international medical body, World Health Organization, what they have to say about HIV and about viral suppression is very important and needs to be taken seriously. So what they stated in that document, they defined a suppressed viral load as 1,000 copies per milliliter. So what they were saying is that anyone with a viral load under 1,000 copies per milliliter has a suppressed viral load, and therefore we can expect that the risk of sexual transmission is incredibly, incredibly low or non-existent. So I'm going to move on to the next slide, and before I do, I just want to flag for Ella that I am not necessarily able to see the Q&A easily. So if you can ever flag, it might be easier if you're able to flag any questions to me by unmuting and letting me know.
Absolutely. No questions at this time, but folks, do
Perfect.
feel free to put your questions in the chat if you'd like, and I will flag those for Andre.
Thank you very much. Okay, so another part of the context of HIV, which is really important to acknowledge and to highlight, is that there are certain communities that have been disproportionately affected, both historically but also currently, by HIV in Canada. Of course, among those most disproportionately impacted groups, we have members of the 2S LGBTQ+ community, and which have been, of course, most historically impacted by HIV. But to this day, we know that roughly 35 to 40% of new cases of HIV in Canada are still among the gay, bisexual, and other men who have sex with men community, and they still represent roughly 50% of cases overall. And because of that, gay men and other men who have sex with men remain the single largest population affected by HIV in Canada, and as well by the prospect of criminalization. Another group which is very much affected by HIV, and it's a growing demographic, are people who use drugs and people who inject drugs. And that is especially the case, we know, in the demographics, the statistics that we see in the prairie provinces, including in Manitoba. As well, we know that Indigenous and Black communities in Canada have been disproportionately impacted by HIV and as well by HIV criminalization. So Indigenous people represent roughly 15 to 20%, if not more, of cases of HIV, despite representing only 5% of the population. And we know that that is tied to historical and socioeconomic factors, stuff like colonialism, systemic racism, different barriers to healthcare, harmful laws and policies. And we know that within the Indigenous community Indigenous women are also disproportionately represented compared to other women in Canada. I noted there was a hand that appeared to have been raised. I don't know if that individual is up. There's something. Are these rural or urban Indigenous communities? So these statistics account for all Indigenous people in Canada. So there's not necessarily a neat delineation between rural and urban Indigenous communities. But I imagine that there are different realities and different statistical situations for both those groups. As well, we know that Black people and Black men specifically are disproportionately represented amongst people living with HIV in Canada. Again, we're looking at roughly 15 to 20% of cases, despite representing only 4%, around 4% of the population. We know that Black men are disproportionately represented amongst the individuals who have been criminalized, including in many cases newcomers, so immigrants to Canada. And all this being said, despite how much has changed in terms of scientific knowledge and treatment options over the past 40, 45 years, still today, stigma and discrimination remain a huge problem in all spheres of life for people living with HIV. So now we're going to move into criminal law, which is going to be helpful to understand a bit what comes later. So this is a 101, a primer on Canadian criminal law. First and foremost, criminal offenses in Canada are found in the Criminal Code, which is a federal law, which means it applies across Canada. There's one criminal code that applies to every province and territory. That being said, the administration of criminal justice happens provincially. So that means there are criminal courts in every province. And how the law works in Canada, which is a common law country, a common law jurisdiction, is that the decisions that judges render in a specific case can set the law and be used to determine how future judges are meant to judge a case with similar facts. So that is what we call this notion of precedent. You're supposed to base the decision in one case based on how previous cases of the same nature were decided. So where this gets tricky in a country like Canada is that the law is applied by judges in every province, but they can interpret the law slightly differently. So a judge in Manitoba does not necessarily have to follow what a judge in British Columbia said. A judge in Manitoba would have to follow what another judge in Manitoba has said, but would not necessarily have to have the same answer as a judge in Nova Scotia. So that kind of complicates things in a way because of how Canada's federal structure works. And this, we'll get to later, is a big issue when it comes to how HIV criminalization and how HIV disclosure laws apply in Canada today. Now, this is a very simplified look at what the criminal process is like. You'll have an individual, a victim, a complainant who has suffered from an alleged crime, a criminal offense. They make a complaint to the police. And in most provinces, it'll be the police who decide whether or not a criminal charge is brought against that person, the accused person. And then that will go to the prosecutor's office, the Crown, and then they will prosecute that case in court during a trial before a judge or a judge and jury in some cases. And then a judge will determine whether or not the person is convicted of that crime. And if they are convicted, they will be sentenced, but they could also be acquitted, found not guilty, and they won't be sentenced. But if they're sentenced, then they could face serious penalties and sentences, including prison time or a whole host of other alternatives. So HIV criminalization, what I'm talking about when I use that term is really to refer to cases where a person faces criminal consequences for not disclosing their HIV status to a sex partner before having sex. And I find it important to make that distinction because in most day-to-day encounters, people living with HIV do not have to disclose their HIV status to others. But because HIV can be transmitted during some sexual activities, the criminal law in Canada has evolved and has determined that in certain cases, people living with HIV must tell their sex partners that they are HIV positive before having sex, and that is what we call the duty to disclose. In terms of history, we know that this phenomenon of HIV criminalization started in the US in the 1980s when the first, cases of HIV emerged. And how they did it down south is that different states, American states, started to adopt HIV-specific laws to prosecute people who knowingly transmitted HIV. That being said, if a law, was adopted in the 1980s to deal with HIV, we can assume that because, they were passed at a time when very little was known about HIV, including how it could be transmitted, including, how it could be treated, or even before treatment options existed. These laws were enacted with the misguided idea that they could protect public health. Over time, we have come to learn that this is not really the case, and actually the opposite is true. And, prosecutions based on this poor, antiquated science have continued, even though the general scientific understanding of HIV has greatly improved and treatment options have greatly improved and become widespread. What's important to note is that in Canada, we proceeded differently. Um, Cases started cropping up in Canada, but they never were brought through HIV-specific laws. What Canadian prosecutors and courts did was use existing offenses in our criminal code, that federal law that I mentioned. I'm going to take a quick break here to see if there are any questions.
No new questions
Perfect.
that have popped up yet.
Okay, so HIV criminalization in Canada. For a long time, Canada had earned, maybe earned is not the right word, but had this shameful distinction of being a hotspot, a global hotspot for HIV criminalization. And that's because there have been over 220 prosecutions in Canada, which, makes it within the top 10 around the world in terms of absolute number of recorded prosecutions, but also one of the highest per capita rates of prosecution for HIV non-disclosure. We also know that Manitoba has represented at least 15 or so of those cases, which, just in terms of the proportion of the population is, it's not disproportionate. It does represent the share of Manitoba's share in the Canadian population. I see that there were, I think, questions that popped up.
Someone's asking if you have any Manitoba specific statistics.
Yeah, so we know that there have been roughly at least 15 cases. And of those, we know that Indigenous people have been disproportionately represented in the people who have been prosecuted in Manitoba. And I'll get to this soon as well. When we look at the Supreme Court case that really set the law, that actually came to us from Manitoba. Okay, now I can see the Q&A. Sentencing outcomes. Well, that's something that I'll get to as well later on in the presentation, but maybe I can give a kind of a preliminary look at sentencing or give you an idea. We know that people who have been criminalized for HIV non-disclosure have faced really harsh, serious criminal sentences because of the crimes they have been accused of, and I'll get to that. And we know that there have been really racist and discriminatory outcomes for Indigenous and Black people who have been prosecuted for HIV non-disclosure, where they have faced harsher sentences compared to non-Indigenous and non-Black people. And we know also that people who have been criminalized for HIV non-disclosure under sexual assault have faced harsher penalties than people who committed sexual assaults involving weapons and whatnot, and really, violent circumstances. The prosecution number for Saskatchewan, I don't have those numbers off the top of my head. Or wait, I think I do actually. Um, Really, the main hotspots in Canada have been Ontario and Quebec. Saskatchewan, the data that I have, which comes from 2022, says only 2 cases in Saskatchewan, at least 2 cases in Saskatchewan that we are aware of, but there may have been more. And also, when we talk about HIV criminalization and the harms of criminalization, I think it's important to highlight for folks that 220 prosecutions in 40 or so years might not seem like a huge number, but what you need to imagine or keep in mind is that it's not just about the people who were criminally prosecuted. It's about the people who, were charged but weren't prosecuted. It's about the people who were, a complaint was made against them to the police. They faced a police investigation, they faced questioning, or they faced threats from, sexual partners or from people that they know that they would rat them out to the police, that they would denounce them for non-disclosure, that they would threaten them with criminalization. So the harms of criminalization come, yes, absolutely, from the prosecutions, but more than that, also from this specter, this of criminalization, this looming threat of criminalization in everyday life. So, like I said, there's no HIV specific criminal offense in Canada. There's not a crime of HIV non-disclosure in the Canadian Criminal Code. How it works is this legal obligation to disclose HIV status to a sex partner, in some cases, was established by the courts, was established by judges, and they did it by interpreting existing criminal code offenses. So there are many different criminal code offenses which have been used, which can be used. These on the slide are some of the most common ones. And I would say the 2 most common ones really are criminal negligence causing bodily harm, and number 1 is, sexual assault and aggravated sexual assault. Now, aggravated sexual assault is one of the most serious crimes in the criminal code. People who are convicted of that offense can face up to life in prison and registration as a sex offender. So why is it that we use sexual assault law in Canada? Because this is actually something that is unique to Canada. And before I get to that, I will check the Q&A.
Yeah, a question just popped up in the chat about is there any kind of disclosure regarding sharing of needles or other activities that could lead to transmission? Thanks.
That's an excellent question, and that is a question that comes up in, I think, every presentation I give of this nature, which really reflects how the epidemic has really changed or how it's evolving, including in Canada, including very much in prairie provinces, where we know that injection drug use is increasingly a vector of transmission. So the law really emerged from the context of sexual relations. And what that means is that it's hard to make generalizations or to transpose the law, how it's been applied to sexual relations, and to anticipate how it could be applied to cases involving shared needles, shared drug equipment, injection drug use. So we might assume or imagine that the law might treat those 2 scenarios similarly, but we don't know for sure because there have been no prosecutions in Canada, to our knowledge, for cases involving shared drug equipment where there was non-disclosure of an individual's HIV status. It's a good question. I wish we had an answer, but for now, I guess what's important to know is that all the cases really, or 99% of the cases come from the context of sexual encounters. So that is what the law really addresses very clearly. And yes, sexual assault law, what I was saying is that it's very specific and unique to Canada to address HIV non-disclosure using this area of law, sexual assault law. There aren't really other countries that do things this way. So how does it work? How do we understand this in Canadian law? Why sexual assault? So generally speaking, you have two or more consenting sexual partners, you have a sexual activity, consent was, freely given, all is well, consensual sexual encounter. When it comes to HIV non-disclosure, what the law says or how it understands it is that not telling your partner your HIV status is considered a fraud. That fraud vitiates or invalidates your partner's consent to sex if they say, well, if I had known that my partner had HIV, I would not have consented to have sex with them. So sex, which occurs through fraudulently obtained consent, ends up being legally qualified as sexual assault. And in the case of HIV, non-disclosure, it can be treated as aggravated sexual assault, which really is used when a sexual assault endangers the life of an individual. So how the law sees these cases is that someone who contracts HIV and that HIV is potentially left untreated, well, that will progress into AIDS, further complications, and will lead to death. So that is why it is treated as aggravated sexual assault, one of the most serious crimes in the criminal code, even though there are, obviously widespread treatment options nowadays in Canada. So what I think is important for people to understand is that non-disclosure can be through an outright lie. A person living with HIV says, I just got tested. I know that I don't have HIV when they know that they do. Or it could be through misrepresentation, not saying one thing or another, or it could be through omission. So the partner doesn't ask the person living with HIV, have you recently been tested? Do you know your status? They don't ask. And so the person living with HIV does not tell. All of these scenarios are treated the same legally because the law imposes a positive obligation on the person living with HIV to disclose their status to their sexual partner, subject to certain conditions, or in some cases that we'll get to. So how the law views it is that if you don't give that disclosure, that is a dishonest act, which can amount to fraud. That being said, people will sometimes think about this and they're like, oh, well, there are a whole bunch of cases where you might lie to a sexual partner, but that doesn't mean it's sexual assault. So let's say, for instance, there's a situation where you lie to someone about being single. You don't have a romantic partner. You're not in a monogamous relationship. You don't have a husband, a wife, a partner, whatnot. And if the partner, the person you have sex with, had known that you were not single, they would not have had sex with you. If they find out after the case, after the fact, would they be able to say, oh, well, you fraudulently obtained my consent. This is sexual assault? No, not under Canadian law, because under Canadian law, you need two elements. The first one is the dishonesty. So lying about something, and in this case, HIV non-disclosure, not disclosing your HIV status to your sexual partner. But you also need a second element, and that element is something that we call deprivation. And essentially, in the case of HIV non-disclosure, we're talking about bodily harm or the possibility of bodily harm. So if you lie about being single, there's no bodily harm that's done to the person you have sex with. If you do not disclose your HIV status and you transmit HIV to another individual, well, then we can understand that there is bodily harm. And if there is no transmission, but you place a person in a situation where they could have contracted HIV, well, then the law will treat that risk of transmission as deprivation as well. I'm going to go to the Q&A and then I'm going to repeat that once more to make it extra clear. Okay, answer live, done. Answer live, done. Oh, okay. We have a
Yeah,
question.
perfect.
Do you need to disclose your status during a sexual assault? This is a good question. It's really an awful scenario where we have actual real life cases which answer the question, and not as you might expect, not as you might hope. We do know that individuals have faced criminal prosecution. People living with HIV have faced criminal prosecution in cases where they did not disclose their status to an individual who sexually assaulted them. So yes, it's awful to say, it's awful to think, to consider, but practically speaking, we do have case law where the courts determine that yes, disclosure is still somehow required in that scenario, which, again, we'll get to this later, but it really illustrates quite clearly that courts don't understand the challenge of disclosure, in a usual scenario, and they don't necessarily have empathy or understanding in scenarios as awful as that one, as like sexual assault. Bridget has a question. What about a person who discloses their HIV status but doesn't disclose that they have a detectable viral load above 200 and they're not on medications? So in that scenario, as long as you disclose your HIV, it doesn't matter whether or not. So if disclosure occurs, then it's up to the other person to make uh, that decision, or to ask further questions. To ask, are you on treatment? Are you on medications? Do you have a detectable or undetectable viral load? If the person living with HIV has disclosed their status, and in a clear fashion, and they have good understanding, a good sense that the person understood them, that they know that they have HIV, then they've done their job. They've fulfilled their legal duty to disclose. They don't necessarily need to get into what their viral load is, whether or not they're on treatment. As long as they clearly disclose their status, well, then it's up to the other person then to decide whether or not they want to go forward with that sexual encounter. So I want to reiterate once more, because like I've said from the beginning, this is not easy. This is complicated. Why is it considered sexual assault under Canadian law? Because if you fraudulently obtain someone's consent, well, then that is not a consensual sexual encounter. HIV non-disclosure is considered fraud in Canada because there is an element of dishonesty. That dishonesty can be through misrepresentation, outright lies, or omission. They're all treated the same. And there's an element of deprivation. So that deprivation comes either from bodily harm, so transmission of HIV, or a risk of bodily harm. And we'll get into what level of risk can be criminalized later. But those are the two elements. You have the dishonesty, you have the deprivation, and that is what leads to it being considered sexual assault. A few other kind of important elements for people to keep in mind, which often come up in questions. First of all, an individual needs knowledge of their HIV status to be held criminally liable. That comes with nuance, though, where if an individual has reason, has clear and objective reason to believe that they might be living with HIV. For instance, they have been experiencing severe symptoms for months now. They're getting very sick. They have been told by 2, 3, 4 recent sexual partners that they have tested for positive for HIV, and they are told you should get tested too. They decide not to get tested, and they keep having these kinds of signs that they might, have the virus, but they're choosing to be, willfully ignorant. That could potentially lead them still to be held criminally liable. It's not, just because they don't have a positive HIV test in front of them. In that scenario, it's an extreme scenario, but still, it is possible that they could be found criminally liable. But generally speaking, you need knowledge of your status. If you had no reason to believe that you were HIV positive and so you didn't disclose to people, then that person will not be criminally prosecuted because they don't have the requisite level of criminal intent, what we call mens rea, to be found, criminally responsible. And another thing that you'll already have kind of understood with how I explained this element of deprivation is that HIV criminalization can happen in cases where it's alleged that HIV was transmitted to a partner, but it can also happen in cases where no transmission occurs. And this is what we typically refer to as cases of exposure. And this is surprising to some folks, but roughly 60% of cases that we know of in Canada did not involve HIV transmission. The majority of cases are these cases of exposure to risk of transmission. So let's get into the nitty-gritty of when is HIV disclosure legally necessary. Generally speaking, people living with HIV have a right to privacy when it comes to their HIV status. Their HIV status is personal health information. It's private, it's to be kept confidential in most cases. There is not a blanket obligation to disclose. There is, however, a duty to disclose, which applies to certain sexual encounters. And there are two main court decisions from the Supreme Court of Canada, which have established this legal duty to disclose, and one of which I mentioned already, maybe your decision originated from a prosecution in Manitoba. So, HIV disclosure to a sexual partner is not legally required in every circumstance. People living with HIV are only required to disclose their HIV status before having sex that poses a significant risk of serious bodily harm. And that risk exists when there is a realistic possibility that they could transmit HIV to their sex partner. So this is a phrase that is super important when we talk about HIV criminalization in Canada, is this concept, this idea of a realistic possibility of HIV transmission. A person living with HIV has a legal duty to disclose their HIV if there is a realistic possibility of HIV transmission in any given sexual encounter. So you would hope, you would expect that the courts, the Supreme Court of Canada, would tell us very clearly what is a realistic possibility of HIV transmission. And unfortunately, what the Supreme Court of Canada did was answer kind of the opposite question. When is there no realistic possibility of HIV transmission? So under Canadian law, the Supreme Court of Canada identified this scenario where, legally speaking, they considered there was no realistic possibility of transmission, and therefore there was no obligation to tell a sex partner your HIV status. So what they determined was that before having vaginal, anal, or oral sex, if a condom is used and a person's viral load is low, so under 1,500 copies per milliliter, that also includes suppressed, that also includes undetectable. If they have both of those elements together, condom use and a low viral load, then the court decided there is no realistic possibility of HIV transmission and therefore no legal duty to disclose. So that was the decision that was rendered by the Supreme Court of Canada in 2012. They said it can't be one or the other. It needs to be both at the same time. In that scenario, no legal duty to disclose. And that essentially establishes a kind of legal baseline that applies across Canada as of 2012. Unfortunately, they didn't necessarily answer more broadly whether there was a legal obligation to disclose in other cases, and that was made a little less clear. So, oh, there's a question that popped up. No, I'm seeing them. Perfect. If the condom breaks during the scenario. Okay, that is a great question that I'll get to later when we talk about condom use and how often are they required to have the viral load tested every 3 months. There's not necessarily a very clear rule that applies nationwide in terms of the frequency of viral load testing, but I'll get to what it looks like in certain provinces, what the standards which have been established are. So what does the science say? That I just told you what the Supreme Court of Canada said about the law, but what does the science say? Because what the law says is a realistic possibility of transmission is not always the same as what the scientific research tells us and has told us for many years about the risk or possibility of HIV transmission. And that leads to this situation where there's not an alignment between Canadian criminal law and scientific consensus. What the Supreme Court of Canada said in that 2012 Make Your decision is, this is what we're setting as the baseline now, but it is possible that future scientific research, future scientific developments could change this legal standard. It could change what counts as a realistic possibility of transmission. But what that means is there's still no clear threshold. There's not a clear statistical amount of risk that the court is ready to say is a realistic possibility of transmission or not. What the Supreme Court of Canada said was, this is the baseline we're comfortable with. We're ready to say if a condom is used and a person has a low viral load, there is no realistic possibility of transmission. But the Supreme Court of Canada kind of said, okay, and for the rest of it, in the future, that might evolve. It'll be up to courts in any given case to evaluate whether there is a realistic possibility of transmission. And what that means is that a lot depends nowadays on how police, prosecutors, and judges in courts evaluate the evidence in front of them in any given case, whether there was a realistic possibility of transmission in the factual scenario that they're faced with. And again, in terms of what has changed since 2012, scientifically speaking, or what has become even clearer, there's been the embrace of the U equals U consensus. There have been also expert scientific consensus statements, one adopted nationally in Canada in 2014 and one internationally in 2018, where scientists, experts in HIV science, have come together to develop these statements to ensure that the criminal justice system correctly understands and applies the latest HIV science. Because scientists, these HIV experts, were realizing that science was being misused by criminal courts, was not being properly understood. And because of that, HIV criminalization was occurring in cases where the risk of transmission was incredibly low or even non-existent. So what they wanted to say or make clear was different scenarios where, based on scientific research, scientific consensus, the possibility of transmission was zero, so none, to negligible. And when we talk about negligible, it's a kind of scientific terminology. We're really talking about super low, 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 almost non-existent level of risk, exceedingly small and, practically zero. But scientists are, going to be very careful when they say something is zero risk or almost zero risk. And, this feeds into a greater discussion that needs to be had about what level of risk are we as a society ready to accept or are we comfortable with? And what level of risk does society think should be criminalized? And the answer is, not necessarily what advocates in the HIV sector would necessarily advocate for. Are law students at university being given the scientific consensus on this? And what is the federal Justice Department doing, if anything, to clarify these murky, confused laws? Great question. Law students at university, I went to McGill. I studied at the law faculty in McGill. I started in 2014. And we did cover HIV non-disclosure in our criminal law class, but we did not go into the scientific research or the scientific consensus, or we did not talk about these consensus statements. And I really doubt that most law students are being exposed to this scientific research, to the scientific consensus, and they're mainly just going about learning about what the law is and just applying the current law. not necessarily always questioning whether the law should be that way, whether the law should change. Now, the Federal Justice Department will get into some of the different measures that the federal government has taken since 2016 to address HIV criminalization. Um, they have taken some measures, and I'll acknowledge those later. But there's a whole, piece on changing the law, which unfortunately they've dropped the ball on, and we'll talk about that later. So in these consensus statements, like I said, they looked at certain scenarios, sexual scenarios, and to look at whether or not, what the risk of transmission would be based on large research studies and looking at the existing literature on this subject. And these are the scenarios where they said they were ready to say the risk of transmission was none to negligible. The first one that I put is, this scenario that is acknowledged already by the Supreme Court of Canada, condom use and low viral load. Yes, we're all in agreement. There's no realistic possibility of transmission. The scientists make it clear, suppressed viral load on its own, zero risk of transmission. So under that 200 copies per milliliter threshold, there is no risk of sexual transmission, even if no condom is used. That is something that, has only gotten clearer and clearer with every passing year, with every new data set. And it's even gotten to the point where, the World Health Organization, like I initially mentioned, is broadening that definition of suppressed viral load based on the statistical data that they have. And the World Health Organization is now ready to say people who have a viral load under 1,000 have a suppressed viral load and therefore cannot transmit to their sexual partners. Condom use alone, and this kind of ties back to the previous one of the previous questions. What we're talking about here is a properly used condom where there is no breakage, there is no allegation of, improper use, of tampering, and on an individual case-by-case basis. Because what happens often is we have this conception or this idea of condoms are 99% effective or not 100% effective, and that often comes from studies that are done at a population level, like a much larger level, and which take into account, the possibility of breakage, the possibility of improper use of a condom, or, tampering, stuff like that. But when we're talking about one sexual act where there is no allegation that the condom broke or whatever or whatnot, scientists are ready to say that a condom is a 100% effective, impermeable barrier against HIV transmission. Oral sex is another scenario where the scientific consensus is overwhelmingly clear that the risk of transmission is incredibly, incredibly small. We're talking again about negligible risk of transmission. And the same is true for stuff like biting or spitting. We have a question. Clearly, police, prosecutors, judges have some elements of racism and homophobia. Based on the stats for this, has anyone asked the Federal Human Rights Commission to get involved with this issue? If not, why not? Again, excellent question. So, yes, this is something that we talk about often in our advocacy efforts, is that HIV criminalization in Canada is definitely influenced and impacted by racism and homophobia and all kinds of different prejudice and discrimination and bias. Whether or not the Federal Human Rights Commission has gotten involved, no. Whether or not this would fall under their mandate, no. And it would be probably a tough case to make. And just because certain groups are disproportionately impacted or, over-policed, over-criminalized, it's often hard to make the demonstration that that happens because of discrimination, and not because, for instance, that group is disproportionately impacted by HIV writ large. So if 2S LGBTQ plus members represent 50% of people living with HIV, you could expect or understand if 50% of cases of HIV criminalization involve that community, because in that scenario, they wouldn't be disproportionately impacted. So it can be hard to make the argument that a group is discriminated against. And the Federal Human Rights Commission, I don't think that this would fall under their mandate because these prosecutions happen in different provinces and territories, and they're not done by a federal prosecutorial body. So it's a good question. It's a bit in the weeds, but the short answer is no. I don't think the Federal Human Rights Commission could or would get involved. How does the potential partner's threshold for risk change things? I.e., a person says, I don't sleep with anyone who is HIV positive, even if undetectable, but the HIV positive person doesn't share their status. Is it fraud? Is it assault? Um, okay. Well, we'll get to the different scenarios where an individual would or would not have a legal obligation to disclose. Um, Basically, whether or not a partner is comfortable with it, if a person doesn't have a legal duty to disclose, well, then their partner's discomfort doesn't make what they did illegal. Let me rephrase that in a way. If partner A is living with HIV, has an undetectable viral load, and they don't disclose their and they don't disclose their HIV status, and a condom is used in their sexual encounter with partner B. Partner B finds out about this afterwards and says, I don't sleep with anyone who is HIV positive, regardless of if they're undetectable or if a condom is used. It doesn't matter that the partner was uncomfortable with that or would not have wanted to sleep with that person, because in that scenario, there was no legal duty to disclose. So again, let me try and restate this to make this clear. It's only sexual assault if fraud is committed, and that fraud needs the two elements, the dishonesty and the deprivation. So in this scenario, dishonesty occurs if person living with HIV does not disclose their status. But in this scenario, there is no deprivation because there is no bodily harm and there is no risk of bodily harm because the person is undetectable and a condom was used. So basically, the Supreme Court of Canada determined in that scenario, there is no fraud. That person does not have a legal duty to disclose. Feel free to mention again in the chat if that wasn't clear or if you want me to reiterate that. But I hope also that covering some of the next points, it'll help make it clearer. So the legal situation in Canada in 2025, we have the 2012 decision from the Supreme Court of Canada, which has left us in this situation where courts have not clearly defined what is a realistic possibility of transmission. They've only said what is not a realistic possibility of transmission. They've said very clearly if a condom is used and the person has a low viral load, that's not a realistic possibility of transmission. But sometimes it can be hard to determine if there is a legal duty to disclose. It can vary from case to case based on several factors. On top of that, different courts in different provinces have come to different conclusions on whether or not they consider that there might be a realistic possibility of transmission and whether or not people need to disclose. So since 2012, these provincial courts have had to apply the standard that the Supreme Court of Canada set in Maybior, and they've had to apply it also to, new fact scenarios, new cases, and based on new scientific evidence. But I started this by saying a court in Manitoba doesn't need to listen necessarily, doesn't need to follow what the court in Quebec says. So the court in Quebec might be comfortable saying, oh, if a person is undetectable, then there is no realistic possibility of transmission, even if no condom is used. But the court in Manitoba can come to a different conclusion. And that is essentially kind of the issue that we've had in Canada, is that the law has evolved at a different pace in different provinces and territory. So, practically speaking, that means that whether a person living with HIV has an obligation to disclose their HIV status, that can depend on the province they're in and the type of sex they have, and that can lead to a lot of uncertainty. So, a person who starts off their day in Ottawa, Ontario, and has oral sex with an individual, and then crosses the river into Gatineau, Quebec, and ends their day by having um, anal sex with and a condom is used, but they have a high viral load, their legal obligations in those two scenarios will be different. So as you can imagine, my understanding is that many, if not all of you, work with communities living with communities of people living with HIV, or are living with HIV, or know people living with HIV. This, you know, uncertainty or inconsistency in how the law applies to different sexual acts and to different provinces makes it very hard to know what a person's legal obligations are. On top of that, we have some provinces and territories which have adopted these prosecutorial guidelines or policies for cases of HIV non-disclosure. And these policies will govern how these cases are meant to be handled. So currently, policies of that nature exist in Ontario, British Columbia, Quebec, Alberta, and there's one, this can be a bit confusing, but bear with me. There's one that was adopted by the Federal Prosecution Service. What's important to know is the federal prosecutors only handle HIV non-disclosure cases in the Northern Territories, in the three territories, Yukon, Nunavut, and Northwest Territories. So essentially, there are prosecutorial guidelines for HIV non-disclosure cases in 4 provinces and the 3 territories, but we don't have anything of that nature in Manitoba, Saskatchewan, New Brunswick, Nova Scotia, PEI, and Newfoundland and Labrador. So now we're going to go to we're going to look at kind of 3 different scenarios and where things are at across the country. Starting with an individual living with HIV who has a suppressed or undetectable viral load. 2012, Supreme Court of Canada set the legal baseline, general rule across Canada, even if a person living with HIV has a suppressed, undetectable, low viral load, they must still wear a condom or they need to disclose their status before sex. Since 2012, in the provinces and territories that have these prosecutorial guidelines, they've gone further. They've accepted the science. They've said that people living with HIV do not have to disclose their status to a sexual partner if they have a suppressed or undetectable viral load, even if they have sex without a condom. So this is not a clearly accepted rule everywhere across Canada. It's only in some provinces and territories, in BC, Ontario, Alberta, Quebec, and the 3 territories. There is no such guidance in Manitoba. So in those provinces and territories, a person living with HIV shall not be prosecuted for non-disclosure if they are on antiretroviral therapy and they have a suppressed or undetectable viral load for a minimum period. And I think this goes back to a question we had previously. In these jurisdictions, I think it's mainly Ontario, Quebec, Alberta, and BC that have this requirement. It needs to be at least 4 to 6 months before the sex takes place. So you need to have, if you have a viral load result from a year ago and nothing more recent, that will not necessarily guarantee that you could not face prosecution because in the interim, your viral load may have changed. For instance, if you're not on treatment, and you might no longer be suppressed. A little asterisk or parentheses, I'm not going to get into the case of what we call elite controllers, individuals who their immune system is innately capable of suppressing HIV in their system without taking medication. That it's incredibly rare. There is some case law on that, but that is obviously not the majority of people living with HIV. So I'm not going to get into that too much. So even though this is it's an emerging practice in certain provinces and territories to acknowledge the science, to say someone who is suppressed or undetectable poses no realistic possibility of transmission and therefore has no legal duty to disclose. There has not yet been a decision, a new decision from the Supreme Court of Canada that would apply across Canada that would make this the law. So that is why, theoretically, on paper, in principle, in the year 2025, in Manitoba, if a person is suppressed or has an undetectable viral load, but they have sex without a condom, they need to disclose their status. If they do not disclose their status, there is the possibility of a criminal prosecution under the current law. We hope, as HIV advocates, as people in this space, that if a case of that nature was actually able to go through all the hurdles, make it through, police, prosecutors, was able to get to a trial, to a judge would acknowledge, would recognize the overwhelming scientific consensus that says there is no realistic possibility of transmission when a person has a suppressed viral load. But until that happens, until we have precedent, a decision in Manitoba that says that, there is no guarantee that an individual could not be prosecuted. So an individual could still face charges. They could still face the threat of charges from a sexual partner. There could still be a police investigation. It's really unfortunate to recognize, but practically speaking, in Manitoba, the law is still what the 2012 Supreme Court of Canada decision says it is: low viral load and condom use. And I've received a question before while organizing this webinar about how does the U equals U, consensus influence the messages that we provide to our community. And I find this tricky or unfortunate because despite really the advances, the liberation of U equals U, of this, very clear scientific consensus that says people who have a suppressed viral load do not pose any risk of transmission, that is it's a very powerful message to provide to, a newly diagnosed person living with HIV or someone on treatment, that if you, take your treatment as prescribed and, continue your medical follow-up, you will be able to suppress your viral load to a place where it'll be under control, you'll be healthier, but also you would hope, you would imagine, you could also tell someone in that scenario, well, then you won't be legally required to disclose. Unfortunately, while I would want to provide that message to people living with HIV, as a lawyer, I also want to balance that with a kind of safety from legal implications. So yes, we want to reassure the newly diagnosed person that if they take their medication and are able to suppress their viral load, that will be fantastic from a health point of view, but also the risk of transmission point of view. But we can't also lie to them or, we need to be upfront with them and tell them that legally speaking, in the province of Manitoba, that doesn't mean that they're safe from prosecution for HIV non-disclosure. So it's a fine line to ride as service providers, as community workers. Yes, we want to reassure people. Yes, we want to give them hope about what undetectable means for them practically, for their health, for the risk of transmission to sexual partners. But we want to balance that message with the tough legal reality that they still have obligations in Manitoba. Okay, question. Why has Manitoba not also got updated guidelines, and how can people pressure the government to get with the times rather than wait for a court case? With a new NDP government, one would expect a more progressive outlook on science. Excellent question. So my organization, the HIV Legal Network, has been working on this issue for decades. and has done a lot of work to pressure to advocate different prosecutorial services in each province to adopt these kinds of guidelines and for those guidelines to align with science. And we have made multiple efforts to advocate to the Manitoba, Crown prosecutors, Director of Prosecutions to adopt guidelines of this nature. Unfortunately, those advances, those have not gotten us to a point where um, they have accepted or they have adopted such a formal public guideline or policy. It is possible, although I think we would know if it was the case, it is possible that maybe they have some kind of confidential internal policy. We know, for instance, in provinces like PEI, which have such a low population, it is almost for them, it's more of a kind of practical consideration. I don't even know that PEI has ever had a case of HIV non-disclosure. So for them, there's less of an impetus in a way to adopt this kind of policy. But I hear you and I agree with you that with a new, more progressively minded provincial government, it does leave, hopefully, room or hope for potentially a guideline or policy of that nature to be adopted in Manitoba. And that's something that people can organize around, advocate, speak to your local member of provincial parliament, MNA, National Assembly, to adopt a policy of that nature and something that our organization will keep doing. When was the last time someone was charged and prosecuted in Manitoba? I don't know absolutely for sure, but definitely within the last 10 years, there have been cases in Manitoba. There have been people who have received prison time for HIV non-disclosure, including in cases where, you know, no transmission occurred. So it's still, I wouldn't be able to say more recently than that. I'd have to, look really into the data more closely for Manitoba specifically, but I can tell you that we know in the past year or two, we have had at least, between 5 to 10 cases nationwide, at least. And this is something that is tough for us to keep track of because it's hard to monitor cases of this nature, in part because there is no HIV specific criminal code offense. It would almost be easier if we could, just research on legal databases any case involving the criminal offense of HIV non-disclosure. But because it is included in those other offenses like aggravated sexual assault, sometimes they can slip through the cracks or we're not going to be informed or alerted of the existence of those cases. Moving on to condom use. So, as I mentioned, the general rule set by the Supreme Court of Canada, if a condom is used, a person living with HIV must still legally disclose their status to their sex partner unless they also have a low viral load that includes suppressed or undetectable. And just to kind of illustrate how, you know, um, wild or unscientific this is, when we know the scientific research is clear that a properly used condom with no breakage, no tampering is 100% effective to prevent HIV transmission. In Ontario, there was a case that was decided by the Ontario Court of Appeal, so confirmed a lower court decision, where a person used a condom in 3 sexual encounters. He did not have a low viral load. It was above 1,500 copies per milliliter. He used a condom. He had no intention to transmit the virus, and there was no transmission to any of the partners, but he was still found guilty, sent to jail for multiple years. We have these prosecutorial policies in British Columbia and in the 3 territories which address condom use. And in BC and the 3 territories, they say that condom use can be a factor that prevents a person living with HIV from being prosecuted for non-disclosure. It's not a guarantee, but it could be an overwhelming factor that would support someone not being prosecuted. And again, there's no such guidance in Manitoba. For oral sex, the general rule would be, based on that 2012 court decision, just because it's oral sex doesn't mean that a person can't be prosecuted for non-disclosure. You would still need the requirement of a condom and low viral load, even though there's a strong scientific consensus that there's zero to almost zero risk of transmission when it comes to oral sex. Again, there is a nuance. We have BC and three territories which have policies which say the prosecutors should generally avoid prosecuting an individual if it's only a case of oral sex involved, but that's not necessarily a guarantee. And again, there's no such guidance in Manitoba. Now, I note that there are 15 minutes left in the session, so I'm going to try and get through these next sections, in a quicker fashion, still emphasizing some of the main points, the problems with HIV criminalization. And it really breaks down to the fact that there's been so much scientific research done on HIV transmission risks during sex. And unfortunately, the law has not caught up to the science in Canada when it comes to viral load, when condoms or oral sex. There are some provinces where it's better than others, but in general, the situation remains problematic. And it leads to a status quo where currently in Canada, people can be criminalized where they have no intent to cause harm or to transmit HIV, where they took appropriate precautions or the risk was low or even non-existent, and even where HIV was not actually transmitted. We also have this problem with inconsistent, uncertain legal standards where courts across the country are coming to different conclusions on whether or not there is a realistic possibility of transmission, where you have some prosecutors who follow the science where others don't. All of that makes it very unclear, very difficult for people living with HIV to know what their legal obligations are. The harms of criminalization. There's been a lot of research done in this area. And one of the most kind of perverse impacts of HIV criminalization is that it's been found that it discourages people from getting tested because people have this misguided idea that if they don't know they are positive, they can't be found guilty of non-disclosure. And I mentioned this earlier. Yes, generally speaking, if you don't know you're positive, then you can't be held criminally liable. But if you should have known, if you were negligent in not getting tested when you had, proper reason to suspect you might have HIV, you could still be criminalized. And in any event, the impact this has is people aren't getting tested. They're not knowing their status. They're not then being able to get treated or counseling. And that's not good for health outcomes overall. And I also want to acknowledge with relation to self-testing, the same applies for a person who tests positive during a self-test. Even if they haven't yet done a confirmatory test, they haven't yet received an official diagnosis, if they have a positive self-test, already that is enough for us to say with, high degree of certainty, that person would have a legal duty to disclose their status, or otherwise use condoms or have a low viral load. Even if they don't have the official confirmation, that's the kind of individual we would have a strong reason to believe that they still have a legal duty to disclose. So how then has self-testing impacted the risks of folks in the context of disclosure? The risks remain the same. The risks of criminal prosecution remain the same, but it's really important for people to have access to legal information and counseling before and after doing self-testing so that they are aware of the potential ramifications, the implications of a positive diagnosis, so that they can get the necessary supports and so that they know, what their legal obligations are, what the consequences might be if they disclose or don't disclose their status to a sexual partner where there is a realistic possibility of transmission. So this is something that our organization advocates for, is really having a human rights-based approach to self-testing, which provides all these wraparound supports to people before, during, and after a self-test. And that also includes people having access to legal information so that they know what their obligations are, their legal obligations under Canadian criminal law. Another point, criminalization discourages open communication with health professionals because people are afraid that their doctors, their nurses, their social workers could be called as witnesses against them in criminal prosecutions. That has happened in many cases. Their medical files have been subpoenaed, requested by courts. And that means that people might, be wary of speaking openly or transparently with their doctor, their nurse, their social worker, if they're afraid that that confidential medical information could be used against them in criminal court. I mentioned this a bit earlier, criminalization, the way that it's handled by courts and judges, the law of non-disclosure, it doesn't really take into consideration the complexity, the challenge of HIV disclosure. It treats it like a black and white issue. You either do it or you don't. If you don't, then you should be criminalized. When in reality, we know it can be way more difficult, fraught, and nuanced than that. We know that people living with HIV are afraid to face violence, ostracism, blackmail, harassment, breakdown of relationships, sexual romantic relationships, threats of charges, retaliation, their, status being disclosed without their knowledge or consent to third parties, and, the risk of non-disclosure law being weaponized against them by vindictive ex-partners, for instance. So those are all factors that aren't necessarily understood or taken into account by Canadian criminal law. And it is also more difficult, we know, for women and gender diverse people living with HIV who might be in scenarios, situations where it's difficult to negotiate safer sex or to disclose their status without fear of violence. And so then they might face a catch-22. If I disclose, I might face violence, physical violence or all kinds of harsh consequences from my sexual partner. But if I don't disclose, I could face legal violence. I could be criminalized and have to go through the system, end up treated like a convict or a sexual offender. So what do they do in that scenario? We have so the law is related solely to sex. It's been applied only to scenarios involving sexual encounters. We think it would apply in a similar way to cases involving shared drug equipment, but we don't have any case law in Canada to that effect, so we don't know for sure. Um, at its core, HIV criminalization in Canada has been marked by discrimination and racism. I've mentioned this both in prosecutions, in sentencing. We know that marginalized communities are most affected. People who, already face barriers related to colonialism, racism, discrimination, stigma, social precarity. They might not be able to have easy access to HIV care, treatment, support, and that can make them more vulnerable to criminalization if they're not able to reach a low viral load as easily or a suppressed viral load as easily. If you think about people who are unhoused, who don't necessarily have easy access to pharmacies or prescribers, who might not be able to adhere to their medication on a daily basis. Those are communities that will then be more at risk of being criminalized. So all of this is incredibly important to keep in mind. And there's been a lot of research done on, the discrimination in HIV criminalization in Canada around, media portrayals, hypersexualization and sensationalism around especially accused who are Black men or Indigenous women. Both those groups have been really harshly or unfairly depicted by Canadian media as hypersexualized. We know that Indigenous and Black communities already are over-policed, over-incarcerated, and there's a lot of discriminatory attitudes and assumptions that come into this about different groups and sexual behavior and, who is sexually responsible or irresponsible, which, when we think about other STIs and maybe disclosure practices in uh, heterosexual communities, for instance, it's easy to see that there's a double standard at play where HIV is singled out and treated way more harshly than any other STI in Canada. And finally, we know that there's no evidence that criminalization is good for public health. The opposite is in fact true. If people are not getting tested, if they're not being transparent with their healthcare professionals. That's not good for public health outcomes. There has been some progress in recent years. I want to leave things on a somewhat optimistic note. Fewer cases being brought forward. You can see on the graph, there's been a steady decline. Some of that comes from growing awareness among law enforcement, among prosecutors and courts and judges around the science of transmission, around HIV science generally. That's also something that trickles down to the general public. If the general public is more educated about U equals U, about what a suppressed viral load is, about what scenarios pose actual or no risk of transmission, then already you can stave off criminalization at the first level. Someone will not complain necessarily to the police or go to the police to denounce someone if they understand that, well, that person was undetectable, there was zero risk of transmission. So there's a lot of, potential reasons why cases have gone down, but it might be in large part because of growing awareness around HIV transmission science and also around HIV treatment options, around new medications like PrEP and PEP. And also, in parallel, there's been this recognition by the federal government, by different ministers of justice, who have publicly acknowledged there are issues around HIV overcriminalization, who have stated time and again that the law is overly broad and punitive. We have, growing recognition from some courts, from some prosecutors, that someone with a suppressed viral load on its own poses no realistic possibility of transmission and therefore should not have an obligation to disclose. We're still waiting for a binding decision for the country as a whole. And we're still waiting for the same kind of acknowledgement, more broadly from courts and prosecutors around condom use on its own without a low viral load and around oral sex. So in those cases, there's still, a risk of prosecution or conviction despite the scientific consensus that goes against that. Now, I want to quickly, before wrapping up this piece on law reform, my organization is part of this coalition of different groups and activists and organizations working to limit HIV criminalization in Canada, which have been advocating for years to change the criminal code at its source by adding language that would prevent criminalization of HIV non-disclosure in certain cases where we know that there is no risk of transmission, where we know that no transmission occurred, or where a person has no intention to transmit, or they've taken reasonable precautions to prevent transmission, like wearing a condom, for instance. We've done a lot of advocacy efforts to the federal government, to different ministers of justice to get the law changed, and we were very hopeful that we were going to make some progress and get something passed to really meaningfully improve the lives and situations of people living with HIV, to improve our own criminal law, to make it align with the scientific consensus, to really reduce and limit the harms of criminalization. Unfortunately, those efforts, I don't want to say came to an end, but have not come to fruition so far. In the fall, we received the really unfortunate news from Minister of Justice Arif Farani from the federal government that the federal government was abandoning its commitment to law reform in this area. And so for now, we need to kind of regroup, see how the political situation in Canada evolves moving forward, if there will be other openings to change the law, to reform the law, to improve the situation under a future government, who knows? And if that is not as politically realistic or feasible, seeing other ways of addressing these issues, like the prosecutorial guidelines, making sure that we expand them nationwide, that we make all of them align with the scientific consensus around viral load, condom use, and oral sex. And also just expand legal education for people living with HIV so they know what their obligations are, for their allies to know as well, for their healthcare providers, community workers, for actors in the justice system. So there's still a lot of work that can be done, notwithstanding this really disappointing recent update. And in closing, just the main takeaways here, the stakes are high for people living with HIV who risk serious criminal penalties, even when there is no or extremely little risk of HIV transmission. HIV disclosure obligations can be unclear for people living with HIV since they can vary from case to case and from province to province. This leaves people feeling unsure about their legal obligations and whether their actions could be criminalized. That's a very scary situation to be in. And we know that HIV criminalization is counterproductive. It undermines public health. We know that the current legal standards are unscientific, unclear, inconsistent. And we know that what we really need are measures that create a safe environment that support people and enables them to seek testing and treatment and to safely disclose their HIV status, free of stigma and discrimination. What we do not need is a punitive approach to HIV prevention, which just perpetuates harm, stigma, and discrimination. So thank you very much for listening. Thank you for the excellent questions that I've received. It is, I think we've come to the end of our hour and a half. I am still available, free, happy to answer questions people might still have in the chat. Happy also to receive any questions that people might have after the session by email. I have my email address on the slide. And then, so these sessions, these public legal education sessions are funded on our part by the Public Health Agency of Canada, who wants to make sure that these webinars or workshops that we're offering are good, that they're doing a good job. So we have these nifty little QR codes that will take you to a survey, which I would kindly ask you, or if you can, if you have the time, if you want to fill out, just to let us know, how you found the session, what we can improve, what we can do better, and yeah, any suggestions you might have. So thank you very much once again. I will turn it over to Ella if there's any more housekeeping. Like I said, I'm happy to continue taking questions if anyone wants to put anything in the chat.
Thank you so much, Andre. I would also encourage folks who are listening today to complete another survey. I know we're very survey overburdened society in general. I put it in the chat. If you have a moment to do it, we appreciate it. Similar to what Andre said, it helps us improve our webinars and continue to receive funding for initiatives like this. I'm also curious for folks that are listening in today, if you have a minute to complete that very short survey, at the end, there's an option to put in your comments. And I'm curious if this is something you'd like to hear more about. I organize 4 webinars per year, and this has been really informative, also a very complicated subject. And I've noticed so much interest and questions in the chat and in the Q&A. So if it's something you'd like to hear more about, I'd be interested just to have that comment in the survey, and would be happy to organize something like this again. And if there are any other questions, do feel free to put them in the Q&A. We'll save a couple minutes here for any last questions.
I'm happy to stick around as long as there are questions, and I'll give it a few minutes if people want to assemble their thoughts. I hope that was clear. I hope that I was able to clearly convey the shit show that is HIV criminalization in Canada in 2025. It's not an easy subject, so thank you all for bearing with me during this presentation. And I hope that you all learned a bunch, and that this will also galvanize some of you to take action. And I definitely encourage you all in your individual, but also potentially organizational capacity to take measures to advocate your provincial government to improve or change or at least adopt prosecutorial policies. It's not a disease, it's an infection. Absolutely. Yeah.
Seeing no other questions, I just want to thank you so much again, Andre, for your time and the excellent presentation. I see folks putting in the Q&A. Just thank you for this amazing presentation. It is a really complicated subject, and you did so well explaining it for us in the best way possible to help people understand where we're at today. So thank you so much again. Thank you everyone who's joined today. And I will send a follow-up email once this presentation is available on our YouTube channel, and as well include the survey for Andre and his contact information if folks would like to follow up one-on-one.
Yes, please feel free. Oh, okay. I have one question. If a person with HIV who is deemed questionably competent continues, I'm not sure. Well, questionably competent. This might like their capacity, if their mental capacity is called into question. Yeah, mental capacity. That is it's a good question. It's a tricky one, which it would have to depend on the case, what exactly the issues at play are. You can imagine, you can expect that that would play on whether or not the court finds that they had the necessary criminal intention to be criminalized. And we know that there are cases where a person can be found not criminally responsible because of mental incapacity or different conditions as well. But I don't know that we have many cases of this nature, so it's hard to know for sure. And I think we can expect, just based on how the courts have treated disclosure in general, that many judges and courts would not necessarily have the empathy or the understanding to treat those cases as we would hope or imagine. The example of sexual assault victims is really illustrative. We also know that domestic people who are victims of domestic violence or survivors of domestic violence have also been criminalized for HIV non-disclosure in really terrible circumstances. So, yeah. Okay. I'll give it another 30 seconds or so, maybe. If not, my email is there. Capretti at hivlegalnetwork.ca. Please feel free to contact me, and I like and share maybe one resource for participants, a Know Your Rights document on HIV criminalization that we have prepared, which is plain language and helps make this even more digestible for folks and in a written format.
Yeah, that's fantastic. We will send that out to everyone that's registered, make sure folks get that into their hands.
Perfect. Okay, well, thank you so much.
Thank
Wishing you
you.
all a lovely afternoon.
You as well. Thank you so much. And thanks for everyone who attended.
Thank you. Bye-bye.